Sources of the law. This is your foundational chapter. What it means that if you're building a building, you want to make sure that your foundation is nice and strong. Then you will have your then you have your building that nobody can destroy, right? So think of this course as the puzzle. There's a lot of pieces in the beginning. And yes, you will feel overwhelmed, and that's normal, that's usual. But we will be giving you the right pieces at the right time, right? And make your life as easy as it can happen, right? So just trust the process, trust everything that we teach you, and just know it's usual to feel how you feel right now, right? Or at the end of this chapter, how you feel. So don't panic. So sources of the law. The first thing we have to talk about is, where does the law started from, right? The real estate law. Where did it all started? It started with this guy. That was the king, William the Conqueror. And he's the one already realized that the land is a valuable asset. And he did not want to give that land to anybody. He said, look, the land belongs to the crown. It belongs to me as a king. And what I will do, I will subdivide that land, and I will give that land to my barons and knights in return for their services. So as long as I'm happy as a king with their services, they can use my land. Their middle lords can use it, their peasantry can use it, they can all use their land. But if I'm not happy with that person, or if I'm cutting their head off, guess what happens to the land? Then he takes the land back, right? So that was kind of the deal, and that's where that real property law, it's all originated from. The interest towards the land, we call it the estates. And even up to this date, you'll hear the word an estate in land, right? What is an estate in land? It's an interest in the land. It's your right to use the land in a specific way. So at this time, he did not give them too much of the estate. He said, look, you can use it, but in return for the services, it's pretty much you can be my tenants, right? And if I don't like you, I'll kick you out, right? So provide the services, you stay. If you fail to provide the services, then guess what? The land will be cut off from you. So my question to you, up to this date, who owns the land? Is that you who owns the land? Let's say you paid millions of dollars and you think, I own the land. Not even up to this date. So no, none of us own the land. It doesn't matter how many millions you pay for this. It still belongs to the crown, which is government now, right? But it belongs to the crown. They have the underlying title to all of the lands that we own in here, that we have in here, right? So what do you have? You have an estate. You have an interest to be on the land. We have different types of estates, which we're going to discuss in different chapter, right? But that's how it works. Nothing belongs to you, right? The land does not belong to us. The house does not belong to you. Even your car does not belong to you. Try to drive that car without the license, right? Without the registration, right? Let's see how long you're going to keep that car for. So basically, for the exams, you have to know the land does not belong to you. There's no such a thing as an absolute ownership up to this date. Because if the government finds a better use, right? If they find a better use for your land, can they come and get it, take it away from you? Oh, yes, they can. That's called the expropriation, right? So when they can come and take it away. If the government say, you know what, we need your house area because we're going to build an airport here, would they even ask for your permission? Say, look, we need your land. They're not going to ask for your permission, right? So what they will do, they will come and they take the land away from you, right? Because they will find a better use for this. So an example, if they say your ownership is absolute, nothing is absolute, right? It belongs to the crown, to the government, right? And you have an estate, you have an interest to stay on the property, right? And we have different types of it, but that's all I want you to understand, right? Now, in different areas of Canada, so on the western side, we have such a thing as called the torrent system, which I'm going to explain in a different chapter, right? But this is the great system to protect your title, your interest in that land, right? And all the BC, Alberta, Saskatchewan, Manitoba, right? We all kind of rely on that torrent system. But if you go towards the Ontario, they have a completely different system down there, right? On the eastern side, completely totally different things. And yes, legislation, our government comes up with the different rules and regulations, and it all different provinces have different stuff, right? So we're going to study what we need to know for this province. So the first thing what we're going to do, we're going to talk about different sources of the law, right? So we have to talk about the common law, the equitable, and the statute, and it's your job to understand which one is the strongest one, right? And yeah, we're going to spend quite a bit of time in here. So let's start with the common law. The common law is the oldest law, right? That's the one that came all the way from England. This is the very strict law, very rigid law, and it's very unflexible law. And this is the type of law that came from the judges. So an exam, if they talk about, they say which law is a judge-made law. So that means the judges are the one who created that law, right? It came from the court system, right? Where the judges say, hey, based on this case, this is what's going to happen, right? So they came up with this law. Can they just come up verbally with this law and say, come on, people, just follow the verbal law? Everything has to be in writing, right? So written decisions, right? And what happens with those written decisions? If I was the judge, let's say in the old days when there was just the common law, and you come in front of me and say, look, Yana, somebody stole my car, right? Help me to get the car back. What do I do as a judge? Can I come up with my own decisions based on the common law? Apparently not. Common law, as I said, is a very strict law, and it's all based on the precedents. So what it means, I have to, as a judge, I have to look at the previous precedents, previous cases from the higher courts, and whatever decision they come up with, I have to take that decision and I have to apply it to my case. Okay? It's called the doctrine of stare decisis. It's a Latin word, and yes, you have to know this word. Let the former decision stand. Doctrine of stare decisis. Let the former decision stand. I cannot make my own decisions. I have to look at the former decision. I have to look at the past precedents, and whatever decision they come up in similar to your case, I will have to take it and I will have to apply it to your case. Now, do you think that's fair enough? Not really, right? Because who knows what type of car somebody else stole, right? So for that reason, people were not that happy at this point, but it created the uniformity. So that means as a judge, could I predict what would happen to you? Yes. And you probably could predict too, right? Because you said, look, if something happened before, similar to my case, then Yana, she cannot come up with her own decision. She has to look at the previous cases, take that case, apply it to this case. So it created the uniform decisions for all the judges. Okay? As I said, not fair enough, right? Not as the best way of dealing with things, but we still have this law. So if I was the judge in the present date, I still gonna use the common law for a lot of different things. Now, why would I use this law for? Because the remedy, if you want money for that car, right? And if I want to grant you remedy, as it's called damages, right? Give you damages, then I have to rely on the common law. That's how it works. So for the exams, your job is to identify the keywords that helps you to understand what are we talking about, right? Because there's a lot of questions that are very, very tricky, and it's your job to understand them well, right? So right now the keyword, if I talk about common law, what's the keyword? England is one of them because it came all the way from England. It's a judge-made law, so that means it's the judges who created those laws for you, right? It has to be not in the verbal way, but in the written decisions, right? It also must be in writing. Doctrine of stare decisis, that's another keyword. Let the former decision stand, so I cannot come up with my own decision. Precedents, if they use that, right? You understand that's the past cases. And the remedies that comes with this is damages. And yes, uniformity, that's what the whole system creates, the uniformity. So basically, if you come to me and say, look, Yana, I want my car, I pimped it out, I made it so cool, I put so many parts in there, nice wheels, get it back from me, somebody stole it from me. And I said, look, based on the common law, I can't ask for the car back because the only remedy that I have as a judge is to grant you what? To give you money, right? And that's your damages. Interesting. So same question, can you get your car back based on the common law? No, you cannot, because the only remedies that we have is money, right? So I said, look, I'll make sure that person pays you. And that's all I can do as a judge. So do you think that's a fair law, right? Is it flexible law? Not as flexible as you want it to be, right? So just must review all and compare all of the facts in the form of past decisions, which is precedents, right? And if there is a difference that his judge feels is crucial, that's a good question. Can the judge distinguish the former case? pieces of the puzzle, lots of keywords. I know it's all kind of a new language for all of you guys. Even if English is your first language, doesn't really matter, right? Everybody gets kind of puzzled up a bit. So what is distinguish? Distinguish is when you set yourself apart, or when you set something apart, right? Point out an essential difference, right? So basically what they're trying to say is this. If I look at your case and I said, yeah, you're right, your car is different from the other cars that I found before, right? Like from the previous cases. Yours is really pimped it out. Yeah, you really did a good job in here. So for that reason, I don't feel that me looking at the previous cases and applying their decision in your case, it's not sufficient enough, right? I don't like that. And as a judge, I want to make my own decision. I do want to make my own decision. I don't want to look at the previous precedents. Can I do this? Yes or no? And they say, yes, you can. The judge allowed to, if he feels there's a lot of crucial facts in this specific case that is not present in the previous cases, then yes, I'm allowed to make my own decision. So if you look at this question, they say, when the judge distinguishes the case on its facts, that means what? When you do questions with me, I want to make sure that you always pause me. Okay, I want you to look at those questions by yourself without me rushing you, and read the question, answer the question, and then unpause me and let's do the question together, okay? Because I go a bit too fast and I know that. Okay, so which one is a better definition for distinguish? One, the judge decides that the facts crucial to the former decisions are not present in the case on hand and does not follow the former decision. Okay, really good. And the judge follows the former decision because the same facts exist in this case which is being decided. So the whole idea of distinguish, he wants to make his own decision, right? He doesn't want to follow, he wants to make his own decision. So my question is, what if, let's say I looked at so many different cases and I looked through the whole Canada court system and I couldn't find not even one case that is similar to yours. Nobody ever stole a car. So if I couldn't find any, other cases similar to yours, can I make my own decision then? What are they asking for? Right? No Canadian cases can be found. Can the judge refer to English cases or other countries with the common law system? So if I don't find nothing in Canada, am I allowed to go to different countries? Can I go to England and look and see if anybody stole the car down there? And that's the thing. I can make my own decisions. I actually have to go look for, any other countries that has the common law. If they adapted the common law, then I have to go back and look at all of their cases. Do you see what I mean? Like, yes. So the hands of the judge are pretty much like they're really tied up, right? And so look, there's not much I can do with the system. Sometimes I can distinguish, right, the facts and say I want to make my decisions, but in most cases, I have to find some other cases. So on the exam, they say you can only look in your province or you can only look in Canada for the former decisions. No, you can go as far as you need to go. Judge, so this is a true and false statements. This is how we test you back and forth, right? Your questions should be on the back of your notes, right? So when you look back, when you look at the notes, all the questions are usually on the back, okay? Judges utilize the doctrine of stare decisis to prevent the uniformity in the law. Doctrine of stare decisis to prevent the uniformity. Is that what they're trying to do? They're trying to prevent something here? No. This is why it's false. They're not preventing the uniformity. They actually encourage them based on common law. That's kind of what the doctrine of stare decisis. Let the former decision stand so we know what kind of outcomes will come from that, right? Not to prevent the uniformity. So that becomes a false statement. Which of the following options with respect to common law system is true? Common law is a statute-based federal parliament-made law. Okay, so every time you do the questions, you want to make sure that you check for the keywords. What do they want to hear from you? In this case, they talk about common law. Okay, in your mind, what do you say? It's England, right? It's uniformity, doctrine of stare decisis. To watch what they're asking you for, true statement, right? So we're looking for true. And then you go through the options. So option one, it says statute-based law, parliament-made law. Who made the common law? Who created all those laws? The judges, right? It's a judge-made law. So for that reason, option one is definitely out. Okay, they're looking for true statement. Option 2, the common law system originated from France. Would be nice, but no. It comes from England. So as you see, option 1 and option 2 is already out. So we have to look at option 3 and 4. Previous decisions from courts in BC are rarely followed due to rapidly changing social conditions. Previous decisions from courts are not followed anymore. So again, if you're not sure about something, you can always skip it and then look at the other options and see which one is a better one, right? Okay, rarely followed. That's something that I don't like it personally, right? But let's look at this one. The central concept of the common law system is stare decisis. Now, is that a keyword? Yes, it is. What does the stare decisis stands for? Let the former decision stand. So definitely this is way better than that option. But yeah, because it says almost never followed, not true. It is followed quite often. As a judge, I'm still going to look at the common law. Okay? That's kind of how it works. So option 4 is what they want. Question, next one. Which of the following statements is true with respect to the doctrine of stare decisis? Let the former decision stand. Let the former decision stand. I'm brainwashing you. It's good for you. All cases that have already been decided in courts are predictable with absolute certainty. Now, we're also going to teach you a lot of keywords that you should be looking for. When I say an absolute, when I say regardless, when I say must be, it's just an indication, or it's just a red flag for you that it could be a false statement. An absolute is way too strong. So for that reason, it becomes a false statement. It with some certainty, yes, but not with the absolute certainty, right? So that one is going to be out. If a court in BC has already decided a particular issue and subsequent court is faced with the same issue, the earlier decision should govern the subsequent decisions. You remember how we say we look from the higher courts, right? Past precedents, and we take those decisions and apply to our case. So this is definitely a true statement, but let's look through the other ones. Decision from anterior courts will have no relevance to courts in BC. It will have relevance. Why? Because you remember, again, we talked about this. If you can't find the cases in your province, then what do? You go as far as you need to go to a different province, right? Or different country even, right? And you still can apply those cases as long as they have the common law. So definitely that's out, none of the above. We do like option number 2 way better, so it should be the right answer, right? Option number 2 is what you want to pick in here. So we talked about the common law. Now you know what that is, right? You should know your keywords by now, right? And you should know what remedy comes with common law. The only thing that the judge can give you as a remedy is damages. Damages is money, right? That's the only thing. You can never ask for the car back. But people said that's not fair. This is not good enough, right? We should come up with something else. So the king came up with the other law. It's called Equitable Law. So he actually created the court of Chancery Court of Equity, where people would go. It's a separate court system where would come there if they don't want just the money, but they want something else, right? They would come to those courts. Now, relief from the harshness of the common law. So for the whole idea of this law system of equitable law, or the equity, is to make it more fair, right? So that's what that is. And now the judge has the other remedies to give you. So now he can actually say, look, we can put injunction. Injunction is when you prevent them from doing something, right? So if somebody punched the other person in the face, what do? You go to court and says, look, you punched me. And the court says, stay away from the other person 300 meters. An injunction, preventing them from doing something, right? Tell them not to do something, to stop doing something. Specific performance is usually applies to contracts, right? When the judge says, hey, you can't just walk away. I'm going to specifically tell you to follow through with that contract, right? Specifically tell you to do something. In real estate, we have a lot of specific performance going on, especially with real estate contracts. If somebody wants to back out, guess what? The judge, it's not always the damages, right? It's usually the specific performance that it goes after, right? Now, mandatory injunction. Please watch. It both sounds like an injunction, but it's two opposite things. One of them tells you to stop doing something. Mandatory injunction tells you to do something. So that's when the court tells you to do something, right? Again, specific is more towards to continue with your contract duty kind of thing. This is for everything else, right? So they tell you to do something, right? Mandatory injunction. Now, do you see any money in here? when it comes to equitable law, do you see any money in here? No. If you want money, then the judge has to look at the common law, right? And at that point, they will go into different courts, right? If somebody wanted the actual car, so if I ask you, can you get the car back based on this law? Yes, you can, because that's where you can ask for things. Now, in 1870, finally, the Judicature Acts actually combined those two systems, the equitable law and the common law, it combined together. Okay, so now instead of going to two different courts and decide, okay, I think I want money, so I'll go towards common law. Oh no, I want my car back, then you would go towards the equitable. No. In this case, this is where they combine. So this Judicature Acts, right, combined the common law and the equitable law. So even up to this date, if you come in front of the judge can look at both laws at the same time. So one judge looks at two laws, common law and the equitable law, and then he's the one who can decide which one is a better one to apply in your case. If he's not sure which one to apply, he always has to go towards the equitable law. The equitable law is the law of fairness. So for that reason, it will prevail. It will win in the court system. It will be the stronger one. So on the exam, if they say which one is the stronger one, which one will prevail, that's a keyword that they like to use, right? Which one will win? The judge will go towards the equitable law, not the common law, right? Common law is the oldest one, equitable will prevail. But he has the option to choose to look at both, right? So my question is, let's say he went towards the equitable law and says, okay, I'll specifically tell the other person to return that car to you. So you got the car. Can the judge also give you a remedy from the common law, which is what? Damages. Can he also say, but also pay that person this much money? No. You see, the judge has to make his mind. If you want the car, then he'll go towards the equitable law. On the specific performance, he tells you to return the car. Okay? If you want the money, then he has to go towards the common law, and then he can give you that remedy. For the exam, watch. If they try to mix and match the remedies, and they say, oh, the judge can give you a specific injunction, and he can give you damages. True, false? False, because they're not mixed and matchable. You can't mix and match, right? It have to be separate, right? So that's kind of like really have to watch for that one. Okay, so we talked about this stuff, right? Canada has two court systems that are combined at this point, right? And if they apply both of the principles, if there's a conflict, they always go towards the equitable law. Always. So based on the equitable law, can you get your car back? Hopefully you said, yes, you can, right? Based on the specific performance. True or false? A party to dispute who is dissatisfied with the decision from the common law court may apply separately to the courts of equity in the hope of receiving a fairer decision. What do you think? Is that true or false? Hopefully you said it's a false statement, because from now on, there's no separate court systems, right? It's all combined in one. So for that reason, they will have to, they'll go to one court. It's not separate anymore. So that's false. True, false? Equitable remedies are always available to parties in court action as a right, regardless of the party's conduct. Do you find this statement, if there's anything too strong in this statement? Does it sound like there's some keywords that might be a bit too much? Hopefully you said yes. What are those keywords I'm looking for that makes it a bit too strong, right, to be a true statement? Always available. I mean, the judge can look at it, but it's up to judge's discretion. So the judge is the one who will make those decisions, not you, right? And if it says regardless of the party's conduct. Like, are you kidding me? So if you're fighting in court, I can kick you out of my court. I can do whatever I want. I might not even settle with both of you guys. Maybe you're not ready at this point, and I'll send you home again. Right? So it's or maybe you took too much time to come to court, right? That could be another example. Why would it take you 20 years to come and sue the other person that he stole your car? Right? It should have done sooner than that. So for that reason, when they say too strong, always, regardless, I mean, not all regardless are false, but not always, but it's indication of the false statements, and it's your job by reading the statement to know if that's true or false. Which of the following is an example of the mandatory injunction? Remember we talked about what's an injunction? Injunction, somebody punch you, stay away, stop doing something, right? Mandatory is opposite. So what is mandatory is when the judge tells you to do something, right? So court orders Sherry to stop dumping toxic waste into the lake. Now they're stopping her from doing that is an injunction, so that's not mandatory injunction. Court orders Assize to pay $5,000 to cover Alistair's medical expenses. What kind of names are those? Okay, pay, that's damages, right? That has nothing to do with mandatory injunction. The court orders Sue to remove the fence encroaching on his neighbor's property, right? So the fence, they tell them what to do to remove something, but it's telling them what to do. So that's definitely a mandatory injunction, right? And the last one, the court orders Sue to stop trespassing, right? So stop, that's injunction. So in this case, option 3 would be the best one. Okay. Next one, which of the following is true with respect to relationship between the common law and the equity? So you see, they're going to go back and forth, and it's your job to know what is the difference. Judge can apply common law principle or equitable principle when deciding a matter, but never both. One sec. They have to make a decision by looking at both laws. So for that reason, that becomes a false statement because they have to look at both laws. And then the judge has to make a decision. Okay, we'll go towards the equitable law, right? Or we'll go towards the common law, right? So, but it says, but never both. No, that's not true, okay? The common law system emerged in response to perceived unfairness in the court of equity. No, one sec. Isn't that opposite? It's the equity law system emerged in response to the common law, right? Unfairness. So for that reason, that's a false statement. The common law is discretionary in nature, where equity operates in a rigid rule-based matter. Again, it's opposite because it's the common law that is rigid, right? So again, that's false. And if there's a conflict between the principle of equity and the rules of common law, equity takes priority. So that's definitely a true statement. As I say, for now, when you study the question, it's your job to pause me, take your time, and understand why is each statement is false statement and which one is a true statement. But on the exam, honestly, you're just going to be scanning through the questions, finding the better versions or find the keywords that you know, and that's how you're going to work through the questions. Everything comes with practice. The more you do the questions, the better you're going to get. Trust me on that. It's a lot of questions we're giving you, right? Okay. Which of the following statements concerning the equitable jurisdiction in the courts is true, right? Again, they're talking about the equitable. Do you see how many keywords that they use? Jurisdiction, they use equity, right? So they're always reversing back and forth, but just know it's kind of the same thing that they're talking about in here, okay? So they're looking for the equitable law and they're looking for the true statement. Where the rules of equity and common law conflict, the court will apply the common law rule. Okay, false because equity will prevail. Okay. Equitable remedies are available to parties in court action as a right regardless of their conduct. Ooh, too strong, right? Regardless of their conduct. We already talked about that. It becomes a false statement. The rules of equity developed as a remedy for the rigidity of the common law in England. So that is a wonderful statement because it has common law in England. It talks about equity as a remedy, right, to the rigidity. So that's the one that they're looking for. Specific performance. Now, you tell me what's the problem with this one. You tell me. Specific performance, injunction, and legal damages are the 3 types of equitable remedies. The problem is the damages, right? Specific performance, injunction, and mandatory injunction. That's something that comes with equitable law, right? Not the damages. Good job. Damages comes under the common law. One more. Best description of equity in relation to the common law. Okay. Equity refers to the legal concept that once a court has laid down a principle of law applicable to the certain set of facts, judges will abide by that principle in subsequent cases. Ooh, that sounds like the common law to me. Equity allows judges to administer justice in accordance with fairness, instead of merely applying the more strictly formulated rules of common law. So you definitely know that option 2 is definitely the best option. This talks about the common law in here, right? So we talked about the common law. We talked about the equitable law, right? Between those two, which one is the stronger one? Good job. The equitable. And now we have the statute law. Now, the statute law is the law created through the government. So the government is the one said, hey, the common law is a bit too old. It's too much. I mean, based on the common law, you can steal somebody's wife, okay? Right now, this day and age, we should not be able to steal people's wives, right? So for that reason, the whole reason of the statute law, right, the government, is to change or to alter the common law, right? Because common law is very old, like super old law, right? So it's your job, it's the statute law, it's the government job to change the common law. So the whole idea of the statute law is to change the common law, right? The legislation, which is your government, right? They come up with different acts. So every time they ask you legislation is, you're looking for the word act in there. So if it's an act, that is a legislation created by the governments, right? It could be a land title act. It's a very common that we're going to be using in this course, or the real estate act, right? That we're going to be using in this course. But if I say the act, that is the statute law created through the governments to change the common law, right? To do some changes. We have three types of governments. The federal government, that's the big guy, right? He's responsible for big matters, right? Banking is one of them. Bankruptcy is a huge one. The currency, right? The postal office is a federal. The marriage and divorce too, right? So apparently it's on the federal level if you're getting divorced. Criminal matters, right? Patents, copyright, shipping, fisheries, national defense, which makes sense. But on the exam, they'll talk about education. And they'll say, look, is that federal government who decides what type of education you will get? Do you see? We teach in so many different provinces, right? So, and every province that I teach you guys, we all have different licensing steps to get licensed. So if in British Columbia, there's only one exam, right, to get licensed for the real estate, right? If you go to Saskatchewan, there's going to be 2 exams, right? If you go to Manitoba, it's going to be 4 exams. So every province has totally different systems. Why? Because it's a provincial government that's responsible for the education, for the administration of justice. That's another thing they're asking for. So provincial, they're responsible for the justice system, right? Police and everything else. Property and civil rights, municipal instructions, right? So this is what they're responsible for. But the education, as I said, it's not federal, right? It's a provincial government who's responsible for that. Now, provincial government is overwhelmed. They have so many responsibilities, right? They're dealing with municipal institutions, and there's just so much, okay? So what they've done, they created for themselves the local municipal governments. And those local municipal governments, they are responsible for all the jobs the provincial government gives them to do, right? So the provincial delegates the responsibility to the provincial, but the provincial itself have no authority to the legislation system. They cannot come up with new rules or anything like this. They cannot change the common law, right? They're pretty much only working with the bylaws, right? That's, don't build higher than whatever, right? That's the local government, basically. Okay, so just know the differences between the 3 types of governments too. So you remember how I said the common law is a foundational law? So you see under the common law, for example, the rules when it comes to licensing, it says an infant can write a contract, right? You don't need to be licensed. And now the statute law overrode that and said, no, right? We want to make sure that whoever is selling the real estate, they have to be licensed under the Real Estate Act, right? You see what I mean? So anytime you see the word the act, that's the statute law, right? It's the change that they created to change the common law. So if I ask you a question, if I was the judge and I had to look at all 3 laws, right? Common law, equitable, statute, which one do I look at first? Okay, it already says in there, right? You look first at, of course, at the most recent laws, which is statute law. And if I don't see the answer here, then I can go back and look at common law and the equitable law. Hopefully by now you already know which one is the stronger one, right? As you see, common law is a foundation, then we have the equitable, then we have a statute, right? So statute will prevail over all of them, right? Is the strongest one. Which of the following could be called legislation? So what is a legislation? It comes from the statute law, and it's anything that talks about the act, right? So just keep it as a keyword for yourself. Any type of acts, that's a legislation. True or false? Common law refers to judge-made law, which is good so far, typically recorded in the written decisions, wonderful, where the statute law refers to the legislation, good keyword, enacted by the governments. Definitely a true statement, a lot of good keywords, we understand them, right? Which of the following option is not a matter in which the federal government has the exclusive authority to pass legislation? So they're talking with the federal government and it's to say which one is not one of the matters, right? Which one is a false statement. Look through all the options. You remember, even marriage and divorce is a federal matter. Bankruptcy, definitely. Criminal, that's a big one. But administration of justice with each province decide how many police they have, how much, whatever, the justice thing. That's definitely not a federal thing, right? But by method of elimination, you'll know. So now we have something you have to know is the two categories of the law, right? Categories is a private law and then there is a public law, right? For the exam private, they like to call it different names. So you will see it, under the civil law, or I'll sue you under the tort law. Tort, civil, private, it all stands for the same thing, right? It's the matter between the individuals only, and there's no government involved in there. It's just between the matter between the individuals. So if we talk about the categories of the laws, we're not talking about the federal government or the provincial government, we're just talking about the categories. The private matters, right, between the individuals, or the civil matters, or the tort, and that's what they call the civil matter, right, between the husband and wife, right? That's private. And yes, your marriage will be here, divorces will be here, right? Breach of the contract, because it's the matter between the two individuals, so that's private. As soon as the government involved, it becomes a public matter. So public law is only three things. Constitutional, it's big stuff. Criminal, so if you kill somebody, right? Or taxational matter, taxes. If you don't pay taxes, now that becomes, the government says, you're not paying my dues, right? Public matter, right? So private and public, very easy to recognize. There's always at least one question in the exam between those two, and it's very easy mark. True, false, an appeal by a taxpayer to reduce the tax assessment would fall within the sphere of the private law. You know it's false, right? Because it's not private, it's public. Three things public: taxational, criminal, constitutional. How about this? Which of the following falls within the category of the public law? I just said them to you, right? Criminal, there's a property law. Dispute between the two individuals and a divorce, right? So criminal is the big one, right? That's the one that you would pick. So now we're going to get to the court systems. Have fun. It's actually pretty good. It's good to know. Good information to know. So before you get to any court system, before we get to actual Supreme Court or the small claims, we're going to talk about smaller matters, right? Something, let's say if you live in the strata building, right? You're paying the strata fees and there's some disputes in the strata, or let's say you haven't paid your strata fees and now they want to come after you. This is where it will go. It will go to the CRT, the Civil Resolution Tribunal, right? CRT, the Civil Resolution Tribunal, right? This is online tribunals. Why is it one of the first places that a lot of people go to? Because it's faster, right? It's online. You don't have to drive anywhere. You can just hop in on Zoom and then you can work on your issues, right? So they work with strata disputes, right? Anything with non-payment of the strata fees, enforcement of the strata bylaws, anything strata related, usually goes through that CRT first, right? Small claims disputes sometimes go through here up to $5,000, right? So if there's anything small up to $5,000, they don't want you to go through small claims. It's too small, right? It's too small, so you have to go through the CRT. So if it's under $5,000, right, you come in here, right? It could be for personal injury, even performance, recovery of personal property, anything under small amount, right? Certain motor vehicle accident injuries, right? Dispute up to $50,000. So here they give you a bit more gap because it's it's an injury, right? So you can come and kind of go through all this stuff. Resolve almost all of the strata, but not all. So again, watch how they say things, right? There's all disputes, not all, right? Some, most of them. So small claims. So again, anything with the small claims up to $5,000, just remember that has to go through these guys. Okay. 3 potential phases involved in here, so you have to know them. So how does it always start? It starts with negotiation, right? So when you start this online thing, you negotiate with them first, parties communicated online, right? Trying to resolve it. If that phase does not work, this is where they facilitate, they actually add the staff in there who will be assisting you, right? Make sure that they try to help you to resolve the issue. And if that step did not work, then you go for step number 3, right? That's adjudication, right? With the adjudicator, right? Actually somebody from not just the staff, but somebody who's supposed to know how to, I guess, negotiate, right? Will make a decision on your behalf. So that somebody will enforce the decision. So try to negotiate. If it doesn't work, they'll get the staff involved. And if not, somebody will be actually making that decision on your behalf, right? Okay, then we have, it's called the administrative tribunals, AT, right? That's another type of way of resolve your issues before you come to court. So basically, they don't want you to go to court. They say try to resolve things before you come to court, right? It's not the part of the court system, so it's separate. It's another ways of working on your issues, right? It's definitely less formal. Adjudicative bodies established to help dispute in specific areas. So on the exam, they say, do they work on every single areas? No. If you kill somebody, good luck, you're not going to come here, right? So they have their own specific areas that they help you resolve the issues, right? It's definitely less formal and it's way easier to get in. Like if you want to try to get in court right now, it's what, 2-3 years wait time, right? So, but if you're not happy with the decision that you end up here, then yes, you can actually take those decisions and the court will review those decisions, right? So disputes will be heard by the courts of original jurisdictions. When they talk about their original jurisdiction courts, that's the courts that have a trial in them, right? And we only have 2 trial courts. One of them is called small claims and the other one is BC Court of Supreme, right? So we have 2 different type of courts that are trial courts. Again, trial courts is where you have the judge, right? The judge will listen to you face to face and you can talk to him. So if I'm back on this administrative tribunals, if they say that these decisions cannot be reviewed by court or you cannot take those decisions from this AT to court, that's a false statement because you can, right? Try to settle here. If it doesn't work, then you go to court and you can go to one of the trial courts. 2 trial courts. The smallest trial court is called the small claims, and this is the court starts from $5,001. Why does it start with a claims of $5,001? Because if it's under the 5,000, that where do you go? Then you go to that CRT. Remember the CRT? Right? So that's where you go up to 5,000. Over 5,000, then you have to go to small claims. Now, this is the trial court where you're going to be in front of the judge. Okay? Back and forth, you're going to tell them your things. Now, this court is territorial. On an exam, you have to know. So again, claims from 5,001, but up to a limit of 35,000. That's why it's a small claims only, up to 35,000 and starting from 5,001. It also has a territorial limitation. So that means you can't take the other person. Let's say if you're the plaintiff and you want to sue somebody, right? You only can take them where the action happened. So if they stole your car somewhere in the middle of the street, right? You can take them in that area. Or where the defendant lives, not where you live, where the defendant lives, right? So that's what they mean by the territorial limitations in here. So be very careful. It's not where you live. So if it's inconvenient for you, too bad for you, right? Don't come to us. That's what they're trying to say. Okay. So if you decide, so if your matter is out more than 35,000, right? Or you want to appeal, right? Then you can go to the BC Court of, so the BC Supreme Court, right? We have 2 Supreme Courts. One is for British Columbia itself only, for our province. And then we have a Supreme Court of Canada, which is a huge one. So BC Supreme Court, that is the highest trial court. We only have 2 trial courts where you see the judge face to face. That's what a trial is, right? 2 trials. So if the only exam they ask you which one is the highest trial court, just remember it's the Supreme Court of BC, right? That's the highest one that we have in here. But this is also the appellate court. So that means you can appeal from this court and go to the next court and the next court if you want to, right? This is the court that does not have any money limitation and no territorial limitation. So that means you can sue them for as much money as you want, right? Most divorces usually settle through this court, right? Because there's no money limitation and you can take them to any court that more convenient to you as a plaintiff, right? Judge may order the new trial. That's the only time that the judge can say, hey, I actually, even if you went through small claims already, I still want to hear everything from the beginning, right? Because you have the judge in front of you. So that's something that you have to know. Okay, so the trial courts in which all evidence is presented, right? So you only work with the judge in here yourself. But if you decided to appeal now, right, because it's an appellate court from BC Supreme Court, what's the next court you go to, right? What's the next one? So the next one that you go to, it will be the BC Court of Appeal. You appealing, right? And if they ask you, what is the highest court in BC? The highest one, that's it, the highest, there's no more. It will be the Court of Appeal. That's it. Now, this court, would you see the judge in front of you? Can you talk face to face with the judge? No, because the only trial courts that we have is up here, right, with the judge in there. Here we have 3 to 5 judges that will review your case. So if you're planning to appeal your case from the Supreme Court of BC and you're not happy with their judge's decision, because you have one judge in here, right, then the other 3 to 5 judges in the Court of Appeal will review that decision. They will not see you face to face, right? They will not rehear the evidence, right? They're not going to do, they're just going to look back at the judge decisions, and if they want to change something, they can. But that's it. Now, what if it's a major case, right? What if it's one of those cases, you know, somebody killed somebody, 20 people. Okay, that's the case diverse. If you want to appeal right from the Court of Appeal, you can do that, then you can go to Supreme Court of Canada. So for the exam, we have 2 Supremes. Remember the rule that 2 Supremes can never be next to each other. They can never touch. They always have to be separated by something else. If you forgot the flow, and I'm sure between the Supreme Court of BC and Canada, you'll figure out that BC is not as big as Canada court. Right? And by the way, this is the smallest court, right? A bit more, and that's the heaviest one. So the flow goes that way. So Supreme Court of Canada, they don't have to hear the every case that will request to go there. You know, they can pick and choose. They have up to 9 judges in here now, right? That's quite a bit of judges in here. And this is the highest appellate court in Canada. So for the exam, there's so many questions they can ask you. Right? Which one is the highest trial court? Which one is the highest trial? Okay, out of the 2 trials, Supreme Court of BC is the highest one. Okay, if I ask you which one is the highest appellate court where you can appeal, okay, in BC is this. But if I say the highest appellate court in Canada, then that will be Supreme Court of Canada, right? So know your flow, know your flow. Question 16, which of the following statements with respect to administrative tribunals is true? So now we're going back to the tribunals. So let's see if you still remember that. Administrative tribunals are considered to be as an appellate court. No, tribunals has no, it has nothing to do with the court system, right? It's a completely separate entity that we'll go to. So that's false. Decision of administrative tribunals are not reviewable by the courts. Remember we said, yes, you can take those to trial courts, right? You can definitely take it. So that's false. Administrative tribunals are not part of the court system. Now that's true because they're definitely not part of it. And administrative tribunals hear disputes across all of the areas. No, they are limited to specific areas, and that's why tribunals are, you know, they're limited. Okay, option 3 is the one they want. This is ABCD questions. Yes, on the exam you'll have the ABCD questions, but we actually like them better because you have all this method. You can use a lot of method of elimination here. So they ask you for the false statement. A, it says BC Supreme Court acts as a trial court only. What do we talk about those keywords? No, because Supreme Court of BC, it's Supreme Court of BC, that's how I call it. It acts as the highest trial and also as an appeal, right? So for that reason, that becomes a false statement, okay? So A is false. So what do I do? They're looking for false. So whatever it has A, I would keep it. Whatever doesn't have A, I would cross it off. Do you see how we have to work with this? So option 2 and 4 is out. Okay, next one. An appeal from small claims court, gonna go to the Court of Appeal. Ooh, that's a bit too far. From small claims all the way to the appeal. No, it goes to the Supreme Court of BC, right? So for that reason, it becomes a false statement. So I already know my answer. It has to be option number 1, right? So it should be A and B, but we're going to continue. Okay, it's false. So that's the answer they're looking for. C, Supreme Court of Canada is the highest appellate court in Canada. That's true, right? There's no higher than this. And BC Supreme Court is the highest trial level in the court of in our province. That is also true. Okay, so you get the idea how to work with this ABCD questions too. Now we're going to talk about the trial process. So what is the trial process? How does it work, right? So basically, yes, so you went through all the other options. You looked at the CRT, you looked at the alternative, you've done all your things. And now you said, you know what, I still want to go through court system. How is it going to start? It's going to start with pleading. So you're going to start with basically as a plaintiff. So you are the one who lost the car, somebody stole your car. You will start, right? So you will start with the notice of a civil claim. Right? It's your notice of your claim saying this is what happened to me, right? It's done by a plaintiff. Sometimes they'll give you a simple question, who does which notice, right? If it's a claim, that's a plaintiff. If it's a response to a civil claim, right? If it's a response, then that becomes a defendant job. So if he wants to defend for himself, he will do a response with his story and tell the judge or write his thing and says, you know what, he gave me that car, right? Present, whatever he wants to say. So both of those steps, we call them pleading. So sometimes they'll ask you, what are the steps of pleading, or what is the step of pleading, right? Notice of a civil claim and the response. So that's the initial step. That's the first step where the two parties gonna put their stories in basically, right? And submit it to the court. Are they gonna see the judge right away? Is that how it works with court system? Right? Definitely not there yet. If you went through divorce, you probably know the drill, right? Now they're going to try to put you through discovery. They're going to try to put you through mediation, arbitration. They try to settle it outside of the court. Make it faster, make it cheaper for yourself. That's what the lawyers will try to tell you, right? So you'll have to go through that discovery step, right? It's kind of like a mini trial. This is where it's under the oath, both parties in front of the lawyers. They basically do a discovery on them, right? They ask them a lot of questions and they're supposed to be under the oath, tell only the truth, right? Maybe a major factor to settle the case, but there's no judge involved, right? That's where the lawyers basically get the information from you and you cannot really lie when they start cross-examine you, right? So you're supposed to tell all the truth. Examine the opposite parties under the oath, can see the strengths and weaknesses of the positions. That's kind of the point of this. And as the plaintiff, yes, they stole your car, but you are the one who have the burden of proof on your shoulders. So what it means in English, it says you'd better prove your case, because if you're going to be in front of the judge and if you don't have enough weight on your scale, right? If you don't have enough evidence, if you don't have enough supported documents, then you're going to get in trouble, because at the end of the day, whoever loses, they have to pay for the cost of the court and maybe even legal fees from the other side. So that's a lot of burden on your shoulders, right? So plaintiff must prove their case. It's called the burden of proof, so they have to, right? And this is why discovery helps both sides, because if plaintiff doesn't have enough proof for his case, then maybe he should not be in front of the judge, right? Who knows how the thing will go. The standard of proof, so sometimes they'll say, what is the standard of proof, right? It's the balance of probabilities. I would even put equals in here. So because if they ask you a question about the standard of proof, what they're looking for is the keyword of balance of probabilities. So now this is, think of it as a scale again. The scale is, you'd better put enough evidence, you'd better prove a lot of proofs on your side of the scale so it becomes heavier, right? The balance, right? The balance of probabilities. So just remember, plaintiff, he has a burden on his shoulders, right? Burden of proof, right? But if they're talking about the standard of proof for each side, they have to balance it out, right? They have to wait it out and see if they have enough true supported documents or evidence. Okay, so now they went through discovery, they haven't settled, let's say. Now they want to be in front of the judge. They understand their, the standard of proof and burden of proof, right? So go through trial. That's with the judge, right? That's where you're going to be in front of the judge. Now the judge, listen to this one. He will start usually with the plaintiff. He will talk to him first. He will look at his things. He will call all of the plaintiff witnesses, right? They will do the cross-examination, so they will work on the plaintiff side first. And when they finish with plaintiff, that's when the judge will go towards the defendant. He will hear his story and he will call his witnesses, right? I'm telling you this for a reason. Okay. And now after the trial is finished, now this is where the judgment comes up. Now that's where the judge will make his decision, right? And he will find out who is guilty, who is not, and who will be paying the other party. Okay. So court costs. Remember we talked about this. As a plaintiff, you have the burden of proof on your shoulders. You better prove your case, right? Partially reimburse the successful party. Whoever is successful, right? They might ask the other side to reimburse you partially for your legal expenses. So that's your lawyer's expenses. And of course, the judge will try to discourage people from bringing weak cases to court because, as you know, it's risk of having to pay costs of the other party of the successful court. So basically, if the burden of proof on your shoulders as a plaintiff and you lost the case, guess what? You might be paying the legal fees for the other person, and you have to pay the court costs on top of it, right? There's a lot of it's a lot of money to be involved, right? Awarded to the discretion of the court. So again, nobody gives you automatically, right? Just because you're the plaintiff, nobody's going to give you money just like that, right? It's up to the judge's discretion. Don't piss off the judge, right? Maybe awarded to either party, but not automatically. So an example will say, oh, it's automatically, somebody's going to get paid. No, good luck. Court costs are not the same as the legal fees. Legal fees is a lawyer. Court fees will be paid separately. Larry entered into the contract with Haley to have her renovate his rental property. Larry later sues Haley for breach of contract, under which standard of proof must Larry prove the breach of the contract. Okay? Keywords, keywords, keywords. If they talk about the standard of proof, I would put equal sign to the balance of probabilities, right? Scale, try to balance it out, right? Okay, good job. True, false. In the trial process, the plaintiff and the defendant alternate in calling their witnesses at one at a time, who are each cross-examined by the opposite side. So I gave you that story about the witnesses, so hopefully you listened. Is that a true, false statement? Plaintiff and defendant alternate in calling their witnesses. False. What does the judge do? He starts with the plaintiff, he listens to all his witnesses, and then he moves on to the defendant, and then they go for his witnesses, right? So they not mix and match in them, because the judge will be very confused. Which of the following occurs during the pleading process? What's pleading again? Pleading made out of two things, right? Which is a notice of a civil claim and a response. So in this case, response is the one that comes as part of the pleading process. Another way of figure out new issues, not going through court, is where you can go through the mediation or the arbitration. We have a separate chapter on negotiation where we're going to be talking about all this more into details, but for now, they just want you to know when it comes to court system, what happens then, right? So that's why they say, look, try to mediate, try to arbitrate, do something before you get in front of the judge, right? Try to settle it. It's less cost. It's way faster. The information stays private, right? It's just better. It's just better, right? Private, informal setting, reduce costs, parties work together, try to achieve the decisions themselves. But this is the interesting part. So now mediation, the M, it's starting to become mandatory in court, because now they have such a thing as called a notice to mediate. They come up with this notice to me. So if one party says, look, I don't want to go through court, I want to go through mediation first. And if he goes to court and he asks for this notice to mediate and he serves the other party, let's say his husband, whatever, right? Her husband. So if they serve the other party, her partner with, let's say if I'm serving my partner, with that notice, that partner is now obligated to go through mediation. Isn't that interesting? That's something new. That's a new thing that they added now. And if they don't come to mediation, then when he comes in front of the judge, he's going to get in trouble from that judge, right? That's kind of how it works now. does not decide the outcome. That's the good part about it. So they say it's kind of mandatory with the form. You go there, but there's nobody, mediator itself, he's not going to decide on your decision. It's not, nobody's going to force you against your will to settle. Right? That's kind of the beauty of this one. And arbitration, that's voluntary. So that means both parties have to agree to do arbitration. It's basically, why is it voluntary? Because if one shows up, the other one doesn't show up, guess what? You can't do arbitration. It has to be both parties have to agree, but they have to agree because with arbitration, the arbitrated decisions, they actually, they are binding on both sides. So arbitrator can enforce the decision on people, right? That's kind of why it's voluntary, because you have to understand that this guy has way more power than the mediator, right? And he can bind you to his decision. It's still flexible, it's still private, right? It's way faster, right? You even have freedom to choose your arbitrator, right? So again, if you go through divorce, the lawyer will say, which one do you like? Right? Commercial leases, they actually have the clause, arbitration clause, saying if you default on the payments, we'll have to go through arbitration, right? And it is private and final. So kind of understand the differences between the two. But again, it's a way better option than going through the court system. Arbitration is, what do you think that is? Required before a party can appeal a judgment. We never talked about that. Where an arbitrator assists the parties to achieve the consensual agreement. Is it? Governed by the common law, not legislation. Binding on both parties at the dispute. Right? So that is a mediation. That is arbitration. Which of the following is true with respect to mediation? So not about mediation. Mediation becoming increasingly difficult to access? No, that's not the whole idea of going through the mediation because it's faster. That's false. Mediation is more expensive and time consuming? False, because it's way better, right? It's cheaper and it's faster. Most mediation proceedings, attendance is mandatory. Okay, we'll talk about this one. And in mediation process, the mediator issues a binding decision. Definitely out because mediator cannot bind you to decisions, but now it's becoming more mandatory, right? So option 3 is definitely better. So did you see how I did that method of elimination? You're pretty much going to do the same thing when you practice on your questions. So how do we enforce the judgment? So the judge, whoever won the case, so let's say you won the case, yes, the judge says, you know what, yes, he stole your car, you know, like let's get something back for you. You become a judgment creditor. It's credit to you because the money will be coming to you, but the person who lost the case, he'll be the judgment debtor. It's a debt to him, so he has to pay you as a creditor, right? So they say, how do you enforce the judgment? First, they're going to go through the examination and of the judgment debtor. So whoever lost the case, they're going to look and examine him. Let's see what kind of car he drives. Let's see what kind of house he has. Does he have any property, right? Does he have any personal property like cars and boats, right? They're going to examine him first, right? To see where did they find those money from. So let's say he owes you $50,000, right? The rate of execution it's an interesting one because when people see the word execution, they're thinking of cutting the head off, right? But this is when you can seize and sell their stuff. Not you personally as a creditor, but you will hire the sheriff and he will come and he will seize his boats and his cars and put a lien against his, that's a different, seize and sell the things and then give you the money for those items, right? So that's execution for the exam. That's a keyword and that's something we can do. So examination, execution, right? Next one is remedies against the land. That's usually putting the lien against the land. So yes, if you found that he has a piece of land, you can go put a caveat on it, right? You can put a lien against this property and it will be frozen until they pay you the money, right? That's kind of how it works. Garnishing wages, yes, you can do that too. So if that person works for somebody, right, an employee, then you can garnish their wages up to 30%. On example, say all of the wages? No. We're not in the communism country yet. So yeah, no, they can't come after all of the all of the money, but up to 30% is okay, right? That's how it usually works. So keywords, wages, the lien against the property, execution is a keyword, right? And judgment debtor, that's another keyword, right? Okay, examination, I mean. Okay, which of the following would not be available to the judgment creditor, which is you in this case, as a means of enforcement a judgment? Examination, right, of the judgment debtor. That's good because that's a key word. Obtaining the writ of execution. Remember the word execution? Apparently we can do that, right? That's season and selling this stuff. Keyword, keyword. Obtaining and selling and garnishing order on the judgment debtor bank's account. So garnishing, right, his bank account. And registering the notice of a civil claim in the appropriate land title office against the judgment. No. Notice of civil claim has nothing to do with the land title office. That's not, it's the lien against the property, right? Not the notice of a civil claim. That's part of your pleading steps. But everything else, garnishing against your bank account, yes, you can do that, right? Keywords, keywords. This exam is all about keywords. Which of the following is not as an available course of action as to a successful plaintiff seeking to enforce the judgment? Which one is not one of them, right? And again, we see the lien, we see the garnishing, we see the execution, but we know that notice of a civil claim is just a pleading step. Has nothing to do with that. So this is the last part, I promise, no more. Limitation period. So we have such a thing, it's called the Limitations Act. And it says that Limitation Act is a default statute. It's just a default, right? The foundation, which doesn't apply to claims under the other statute laws that already have their own limitation period. So basically, this is kind of a foundation to all the limitations. And if the other statutes have their own limitations, then they will override this. This is kind of a foundation. So for the exams, you have to know we have two different foundations. One of them is called the basic limitation period, which is 2 years. So yes, somebody stole the car from you, you come in front of the judge, and 3 years pass by. And I said, why did it take you that long? Or 20 years pass by, right? So they say, especially when it comes to physical injury, so if somebody actually hit you by a car, you have up to 2 years only, right? Physical injury, usually only up to 2 years. Applies to, as they say, most of the civil claims. So if you come in front of the judge and something happened to you, I don't know, 5 years ago, I would say, why did it take you so long to come to see me, right? And I would just dismiss your claim. So yes, try to do it within the first 2 years. Begin on the date of the discovery. That's where the tricky comes. Discovery of the negligence. I wish we could rephrase that, but that's how it's on the exam, so we can't touch it. So basically, on the date where you they stole your car, sorry, it's not on the day when they stole, it's when you actually discover that they stole your car. So let's say you were on vacation for 2 months and then you came back and there's no car. Even though they stole the car maybe 2 months ago, it's not about that date. It's about when did you discover that they stole the car from you, right? From that date, that's where that limitation period starts, okay? And it's not on the date of the acknowledgement. So if you found the person who is guilty and you say, you stole my car, and he says, yeah, I'm so sorry, and he acknowledged, it's not about his acknowledgement, right? So it's about you when you discover that, right? That's when that limitation starts. The ultimate limitation period is up to 15 years. Now, this is a different type of limitation. And yes, in your UBC books, they don't really specify. But from all the other information I've been teaching, I kind of know what they're referring to. This applies more towards, let's say, kids. Right? Somebody did something to you and you did not know how to even work on that. You know, like you said, like, I don't know, I didn't know that that was, you know, not supposed to happen to me. And then later in life, you've realized, so you have up to 15 years, right? So usually it applies to infants, applies to somebody who is not, cannot capable to make decisions, right? Those kind of things, that's where the judge gives you extra time and says, you know what, you have up to 15 years to come in front of the judge. Again, for the exams, just know that there's another limitation. Begins from the day on which the act actually occurred. So this is where, you know, if it happened, let's say 12 years ago, and now you realize, oh my God, you know, okay, I don't want to get into the subjects, right? But okay, so I want to take somebody to court. This is when it's happened, right? That's where it starts. You can rely on the common law, right? Basically, it says only brings the action within the limitation period. So as long as you just want damages from them, that's okay. You can apply within those 15 years. But if you want to rely on the equitable law, and you can specifically tell them what to do, or maybe you want something else from them, right? You want that car back, maybe, right? Then you have to bring it within both limitation period and within the reasonable amount of time. That's up to the judge to decide, right? Is it reasonable or not? This is interesting. Sometimes, as let's say, if the person who stole your car, he can reset the limitation period himself. And this is where the lawyers get involved quickly and says, don't say anything, don't give them any money, saying I'm sorry for stealing your car, don't acknowledge it, because as soon as you acknowledge it as a defendant, right, then it resets to that date of the acknowledgement. So it's interesting. So a defendant acknowledges liability, both of those limitation periods will reset to begin of the date of the acknowledgement. Interesting, right? And if the court action is brought against you, consult the lawyer as soon as possible to make sure that you don't accidentally acknowledge liability, right, and reset the limitation period. Questions are not as bad. So look at this one. Lisa is leasing a commercial property for 5-year term. After business hours, John trespasses on the property. Generally, what is the basic limitation period under the Limitation Act, which Lisa may bring a legal action against John? So he's just trespassing. He's walking through her property. Right? How much do you think the judge, what do you think is limitation period to apply here? Would the judge give him her 15 years to go after this person? I don't think so, right? It's definitely within the 2 years. Bring the claim, right, within the 2 years of the discovery of the trespass. Next one. Rohan and Adeline enter into the contract of sale and purchase in Adeline's house. After the transaction is completed, Adeline decides that she no longer wants to proceed with the sale and refuses to transfer the property. 20 months later, Rohan initiates legal proceedings against Adeline for the breach of the contract. Equity might not intervene because of what? So the equity, remember, it has to be both. It has to be within the reasonable time and it has to be within those limitation periods. Equity only operates in public laws. Nope. Ultimate limitation period has expired. Ultimate is 15 years. Nope. The basic limitation period has expired. 2 years. Nope. It hasn't expired yet. It's 20 months, I think, right? A reasonable amount of time has elapsed. So yes, in this case, again, it's, you know, like it's a contract. And if you want to sue somebody, then don't take 20 months, right? Do you see what I mean? Like that's how the judge will look at it. And that's why the equity will not apply in this case. Because the judge said, again, it's a bit too long, right? In judge's opinion. Which of the following is true regarding the Limitation Act? Right, let's see. Now we talk about the act. In order for the basic limitation period to apply, a claimant must file a claim under the statute that acknowledges the Limitation Act applies. No, we never talked about that. The basic limitation period only begins once liability is acknowledged. No. If the potential defendant acknowledges liability, the ultimate limitation period is reset to the beginning of the date of the acknowledgement. That's what you're looking for, right? Remember, try not to acknowledge it, right? If you're the one who stole the car, keep it shut, right? That's what they want you to say. Okay, so this is the chapter. And oh my gosh, you probably feel like that's a lot of puzzle pieces here, just in one chapter. And it's true, UBC is expanding and expanding and expanding. And I've been teaching you guys for the last 23 years this year. So I know how small this chapter used to be and how big it is now. Yes, there's a lot of information, but as I said, just you know, no dieting. If you need to go cry in the shower, go ahead. If you need to punch the wall, go ahead. But come back and rewatch it again. We have multiple instructors for the same chapter, so maybe it makes sense for you to watch another instructor, right? And then just listen to and see what's the best fit and who do you get the information from better, right? And then make sure that you do your quizzes. So honestly, in the beginning, it feels like it's a lot of information, but then it gets better. And all the pieces, right, as I said, the start fit in perfectly. And by the time you finish the course, you'll be all done and you'll know it all. right? So just relax. Don't worry about it too much. Okay, guys, I'll see you in the next chapter very soon.